Mr. Camp, good
Yes,
morning.
ma'am. Morning, Judge. It's a pleasure to be back in front of the court. My name is David Camp. I am representing the appellant in this case, Mr. Aaron Couvertier. At this time, with the court's permission, I'd like to reserve 3 minutes for rebuttal, if I may, please.
Yes, sir.
This is a matter that is actually somewhat limited. It is not something, I think, quite frankly, that is involving reviewing an entire trial. It is a matter involving sentencing. Basically, it's a more pointed issue, even beyond that of sentencing, in that it deals with and addresses the question regarding whether or not Mr. Couvertier was not given diversion, which he wasn't, and whether or not that was proper under the circumstances. I think the case law is relatively clear in this case. The brief that I provided to the court, I hope, has helped to give the court some insight and instruction and direction in this case. I would give the court a brief bit of history, if I may. It began, of course, with Mr. Couvertier being indicted on April 29th of 2024. He ultimately pled guilty on July 8th of 2024 to the count of aggravated statutory rape, 1 count. It was the only count of which he was facing. Ultimately, the facts of this case are Mr. Couvertier got into a relationship with a young lady who was 17 years of age. I think she was about 3 months shy of her 18th birthday. At that point in time, I think it came light over about a month this relationship went on. Ultimately, I think it got to the attention of law enforcement because she was 17, he was much older than her. Ultimately, more than 10 years, which led to the aggravated statutory rape charge that he faced. And he pled guilty to that, stepped up, owned it, and then basically said he was responsible for the events that took place. It was a blind plea, as the court's aware through the brief. The blind plea meaning, as the court's very much aware, that there was no sentence agreed upon, no recommendation made at that point by the state. And really the ultimate issue was going to be he was facing 2 to 4 years. That was a Class D felony. And it was a question of whether or not he should, in fact, be granted diversion. This is, of course, a diversion-eligible criminal offense. It also showed that there was a TBI eligibility report that was performed, and it showed that he was eligible under the rules and requirements for judicial diversion there. Where the point of issue for Mr. Couvertier is the manner in which the sentencing hearing was conducted. And we can focus our attention on the sentencing hearing. It's a transcript, I think, volume 3 has been filed with the record. And I pointed out to the court, and I said this is what's in the brief, is that when it came time for a decision to be made by the trial court whether or not Mr. Couvertier should be in fact granted diversion, the trial court's finding was summed up in 7 words. It said, "I don't think diversion will be appropriate." That's it. That's the only thing the court said in determining whether or not Mr. Couvertier should be granted diversion. Now, this is black letter law. And this court has dealt with this issue before. This is not new. It's not precedent. It's not a first impression. In fact, as recently, I think, for the court is 2024, Judge McMullen, you were involved in the State v. Batten decision, although it wasn't an oral argument made. It was done on briefs. But in that case, and I'll read directly from that opinion from the court said the following: "The record should reflect that the trial court considered the Parker and electroplating factors, which the court is aware is the precedent upon which this court relies in determining whether or not the trial court properly decided the factors necessary to determine if diversion is in fact acceptable." And it says, under that fact, the Parker and electroplating factors in rendering its decision, and that it identifies the specific factors applicable to the case before it. Thereafter, the trial court may proceed to solely address the relevant factors. Failure to consider the common law factors results in a loss of the presumption of reasonableness, and the Criminal Court of Appeals will either conduct a de novo review or remand the case to the trial court for reconsideration. The determination as to whether to do de novo or to remand is solely within the discretion of this court. What the court has before it, and I think what ultimately happened, and I didn't try the case. I wasn't representing him in the trial court. Another colleague that's a very esteemed attorney here in Jackson represented him in the trial level. There were a number of evidence and testimony and exhibits that were introduced during the sentencing, but it seemed as if the focus was more along the lines of probation. And could he, in fact, be given probation rather than have a sentence of confinement in this case? And it looks as if the trial court directed most of its focus on the mitigating and enhancement factors involving the sentencing issues.
Mr. Kemp, let me
Yes,
just
ma'am.
stop you for a second. Was the trial court aware of the defendant's eligibility for judicial diversion?
Yes, ma'am. The TBI eligibility report was made an exhibit during the course of the sentencing hearing, and it was specifically said to the court, we are seeking judicial diversion, thus the reason for the court's 7-word statement in the instance.
Okay, so the
court was aware.
defendant here was convicted of or pled guilty to aggravated statutory rape.
Yes, ma'am.
Okay, so even though aggravated statutory rape is not explicitly defined as a sexual offense in the judicial diversion statute, what difference is statutory rape by an authority figure, which is covered, what's the difference between what happened here factually and statutory rape by an authority figure, which is covered or defined as a sexual offense?
Yes, ma'am.
Which precludes judicial diversion.
Yes, ma'am. I don't, well, in this case, I assume the facts have to distinguish. I'm trying to understand the court's question. I think I understand it. I'll try to work within its parameters. But this is a situation where this young lady was a babysitter in their home. I think that's a given. She was employed for that purpose of providing babysitting services. At no time was I aware of that any reference was made or inference made to the trial court that this was an attempt to say that he took authority figure over her as it relates that you might see in some other type settings. It clearly didn't fit within the definition of authority figure as you often would see it. This was not a situation, if the court please, where he had any, I would submit to the court, direct control over her from the perspective other than she was watching their son. I think at that point he was at home with her, and I think that it developed into a relationship. And of course, you can't say consensual because of the age, but I think under the circumstances there was definitely some what I refer to, I guess, as give and take between the parties. In this case, both parties participated in this activity. Again, she was young and underage, and I'm not trying to excuse that. I'm
Sure.
sorry, pointing. I would submit to Your Honor, it just didn't fit within the confines of the definition of statutory, but I agree with the court.
I guess I'm just assuming that you're correct and we operate under de novo review because the trial court did not explicitly refer to or weigh any of the electroplating or Parker factors. I was a little curious because he was the parent slash employer figure over this young lady. She was employed by him.
Yes, ma'am.
And there was a significant testimony about the grooming and the manipulative nature and the fact that this occurred over a period of months. All of those things were testified to, and I'm looking at under or through the eyes of de novo review.
Yes, ma'am. Well, let me address that if I may, because I think that raises a very excellent point about what to address here. In this particular instance, the court will recall the pre-sentence report indicated that there was a very low risk here, and that was one of the issues that was relied upon concerning the conduct and the behavior of whether he would be a repeat offender. There was references made to what the court said, I think primarily by the mother of the victim, who a victim was not there. The mother, I think, read a letter perhaps that the victim had prepared. The mother gave her opinion about it, to what extent that opinion may count, but basically was passing judgment on, in this case, Mr. Couvertier, and making those type of references in those statements. And what's concerning is were they necessarily based in fact, or were they conclusory in nature? Were they somehow based upon anger and frustration on her part, making accusations against him? There was no evidence presented. There was no psychosexual evaluation. There was nothing there in the way of an expert or anything even close to an expert to say that, one, he either had done this in the past, that he had a propensity to do this, or that he would do so in the future. And I think those allegations were made, and I think even the grooming allegation was made in this case. And I think under the circumstances, if the court pleased, that was all taken into account and weighed. It didn't rise to the level of authority figure, which is a completely different statute from under which it goes. If this court conducts a de novo review, which I think this court has authority to do, and I'll address that in one moment if I may, during the court's question. In the brief that's been submitted by Mr. Couvertier, beginning on page 10, I have taken the liberty on behalf of Mr. Couvertier with setting out every factor that the court should consider in determining whether to grant diversion and laying out those facts that were presented during the course of the hearing that would support granting diversion in this case. And it goes on through, if the court please, to almost the end of the brief. I think it's several pages there, but each one is highlighted, bold printed, and explained what those factors are and what was presented during the sentencing hearing that would have supported diversion had the court taken the time to have at least weighed those factors. And that's what we would rely on. And I did it as a preemptive measure because I knew the court had an option of going one way or the other. So even in spite of Your Honor's concerns there, the question is, to what extent does that concern fit into the factors that the court has to look at in making that determination? And in this case, I would submit that is a factor the court can consider, but I don't think it is necessarily the sole factor upon which the court should rely. I think there are so many other factors that support diversion that I've outlined there. In fact, I put in page 10 of the brief, and I know the court can read this, but I set out all of these testimony statements that supported this individual. He served our country, he was disabled, he was injured while in service of our country, honorably discharged as a result of the disability that he sustained. He did have mental issues and emotional issues that he had dealt with as a result of his time in the service, and that he also had spent his entire life finding areas to work in that dealt with serving others and being someone that could make people better. Was this necessarily a characteristic of the kind of individual that he was? The answer is no. And the reason we know that is because the person that knew him best, and that's his wife, actually came forward, testified on his behalf, and supported him, saying this was not the kind of person that he was, and that she was as much upset with, obviously, and angry with him for what he had done, but also understood that he had reasons for things that may have occurred, and that he was seeking help to address and deal with those problems. And those are the things when we talk about amenability to correction, or when we talk about the other factors that are considered within judicial diversion that qualify this gentleman for having been granted, and it should have been granted, this diversion. There is a concerning issue that also I would bring to the court's attention. There is, as the court is well aware by looking at the record, at least 3 attempts have been made by Mr. Couvertier to get a bond while he's been on appeal. Concerning is that he's got a 2-year sentence. He's already 1 year into that sentence. As of September 9th of this year, he will have served 1 year. If the court remands this back, as I indicate, and I think the record's so clear that it should be either remanded or de novo review because of the absence of any ruling by the trial court as required under the electroplating decision, then is more time will be taken as well toward his continuing to serve that sentence. And obviously we're at a point where we're clearly looking to the court for relief on that. So if it's remanded, we assume he'll stay in custody, and if there's a ruling made by the trial court, that may result in an appeal coming back before this court. By the time this is all over, he will have done his 2 years. The significance of that is, as the court's well aware, if he's granted judicial diversion, he gets deferred probation. He is still on the registry. I think there's no question that would be the case. And so under the circumstances, there are protections and precautions that are there. And at the same time, it recognizes that there are individuals that can make bad decisions that doesn't necessarily make them bad people. And so we ask the court under the circumstances, based on what's in the brief and also what's put in the transcript and what limited information there is, to overrule and reverse the decision of the trial court denying the diversion, and to make those decisions that this court feels is appropriate, either through de novo review or through remand back to the trial court for further findings for that court to make in line with the decisions that I think this court believes that should be done. So we would appreciate the court considering doing that.
Thank you, Mr. Kemp.
Mr. Kemp, may I ask you a question before you sit down?
I'm sorry.
It's been a pleasure listening to your argument and reading your brief today. I wish we had met in Knox County. Would have loved to have you practice there where I was.
I take that as a compliment. Thank you.
Every trial judge has their own different ways of doing sentencing, and I was very explicit when I did it about, okay, I'm considering mitigation now, I'm considering enhancement now, I'm considering diversion now. But not every judge does that. And as I was reading through the trial judge's reasoning in the sentencing, he does make reference to most, if not all. I think there's one, the amenability correction, I think there's no reference to that. But he says the court considers the defendant's physical and mental condition and social history, and talks about being disabled veteran. The court considers the circumstances surrounding the offense. The court takes note he has no criminal history. So it looked to me like in the midst of talking about enhancement mitigation together, he was considering most of the electroplating factors? Are you saying that the court has to specifically say, I'm considering these factors in my decision on diversion, or can they just sort of lump all that in together?
I think the answer is somewhere in the middle of that, Judge Sword, if I may, and the answer that I'm referring to is that do you have to go in and say, okay, I'm going to go down electroplating and give you every factor point by point? The answer is I don't think that would be required. I don't think the case law supports that. But I think what you have to do is you have to be able to delineate, even for purposes of appellate review, I'm not agreeing to diversion, and here's the reasons why. And I think it has to be set out where at least he's addressing, the court is addressing the diversion aspect of it and setting out those exact reasons for what the reason for the court is. Otherwise, how do we know specifically what the court's rationale was? Are we talking about he's not given probation and this is the reason we're not looking at it, but hey, we're supposed to bootstrap in the factors that he said over here that might also apply under electroplating for judicial diversion, which is a completely different animal? I would submit to the court that it has to have there has to be some distinction made. There has to be some deference. There has to be something. Even in the State v. Smith case that that the government cited in its brief, it's clear that that judge even said for purposes of judicial diversion, I'm going to find that these factors work against that. Even in the Batten case where the reference was made to 2 points of the factors for judicial diversion, but no reference made to the other factors. This court found that judicial diversion was not properly addressed by the trial court in reverse. So in answer to your question, no, I do not believe that you can group all that together and then make that have to somehow be sorted through in some kind of sifter where you figure out, well, this one's about probation, this is about enhancement or mitigation factors for sentencing, this one's about diversion. You have to specify the diversion aspect. Otherwise, we have no idea why Judge Howe did what he did. And I mean, I have the greatest respect for Judge Howe. I tried a lot of cases with him when he was in the bar, and I certainly appreciate him on the bench. But the reality is, it's just something that was just missed, and we think that it should be addressed.
Thank you, sir.
Yes, sir.
General May, it's good to see you.
Good morning, Your Honors. Nice to see you today. The court should affirm the judgments of the trial court. While the trial court did not cite electrolyting and Parker in its analysis, as this court, as Judge Sword pointed out, did address overall and generally in lumping together the analysis. Was that best practice? No.
Where was the weighing?
Well, in its analysis, in about page 35 to 37, if I remember correctly, it went through the mitigating enhancement factors and discussed overall the analysis of what we would view as the probationary factors, and in the end, part and parcel within that, it did discuss different aspects of the.
I give you, Mr. May, that it discussed various aspects of the factors, the common law factors, but there was no weighing as to why it ruled one factor outweighed the other for purposes of judicial diversion. None.
No.
And that's what King requires, right?
Yes. The best practice and what should have happened is it distinguished between the probationary analysis as well as the judicial diversion analysis. That did not, the distinction and analysis separately and analyzing did not occur here. And while it's the state's position, if this court were to fall down and move forward into the de novo review, it's the state's position that the facts in this case were egregious. The circumstances of the offense are horrendous. While my friend on the other side mentioned there wasn't anything in the evidence regarding the impact on the child, and I will refer to her as she was a minor child. And though she was 17, it's still a minor child who was there babysitting. And this family had a relationship. HG is her initials, and that's why I'll refer to her when I do. Had a relationship with her older sister had babysit for this family, and then she started babysitting for this family. And so it was an ongoing relationship with this family. And during that time, over a month period of time, the defendant, who was 32 at the time, began a sexual relationship with her. And it's clear from that, and that began in October, and she reported at the beginning of November 2023, that he had multiple acts of aggravated statutory rape over that period of that time while she was babysitting his child in that same house.
So, General, I don't think anyone's minimizing the seriousness of the facts here, but did the trial court say on the record that due to the circumstances of this offense, it outweighs all other factors favoring diversion, and for that reason, I'm denying diversion?
Well, the court never even truly said separated out diversion or probation. It did find that the circumstance of offense weighed heavier than every other factor. The circumstance of offense and deterrence in general. It did not say specifically for diversion, but it said that those weighed more significantly than the factors that, as the defense points out, are good for the defendant. He had the work history, he had no criminal history, he had the family relationship, had mental health histories. But it's the state's position that those pale in comparison to the circumstance of offense and the need for deterrence in this situation. And one thing that I do want to point out, that it did feel that the defense sort of shed very little light on the circumstances of the offense. If you look at Volume 4, Exhibit 1, 9 through 12, is actually the police report where it details in explicit detail that this child came forward and described the events that occurred to her and the grooming. And that is a word that she used. In her victim impact statement, which is a part of the pre-sentence report, she specifically says, very good at lying and deceiving, manipulating and guilt tripping. He lied to me. He used me for what he wanted, my virginity, and wrecked my entire world. I was gaslit by a professional, still trying to pick up the pieces and push forward with my life, depression, thoughts of suicide, guilt, shame, unworthiness, anxiety. I'll never be able to do, he should never be able to do this to anyone else, especially another young girl. Then her mother did testify at the hearing, and she talked about the inappropriateness, manipulative behavior and actions that he committed towards her daughter, and described him as a sexual predator. And the facts hold out to that, what he stipulated to in his plea that he did. And it wasn't specifically pointed here in his argument today, but in his briefs, it focuses a lot on the remorse that he claims that he presented. Well, if you look at the letter, he did not testify at the hearing. His wife presented a letter from him. And if you look at the letter, he does say, I'm sorry, but it's more sorry to himself for being caught and sorry to his family for what he's putting his family through. And that, again, is what he focuses so much on his bond concern, is the financial impact on his family. It's not the remorse of what you would expect at a sentencing hearing. And again, in the end, it's the defendant's burden to show that while aggravated statutory rape, unbelievably so, is a diversion eligible offense, it's the defendant's burden to show he is an appropriate candidate for diversion, and he simply failed to do it. The facts
General,
Yes,
I'm sorry to interrupt, but I would really like to get back to the adequacy of the trial court's ruling here, because I think Mr. Camp made a point we can probably all agree on, that you don't have to say, okay, this is electroplating factor 1, this is factor number 2, this is 3. But at the other end of the spectrum, he's alleging what happened here was that the judge did not articulate why he was denying diversion. These are two separate analyses. You don't even have a judgment to sentence until you make the diversionary decision, because you're diverting judgment if that particular analysis falls in the defendant's favor. So at what point along that spectrum does the state believe that a trial judge has to articulate its reasoning? And are we not giving short shrift to the separate analyses here in this case if we say that this is adequate? I asked a lot of questions.
You did
there.
it in that one thing. I'm trying to succinctly respond to it. You know, it's the state's position that the court did not distinguish and analyze individually diversion and probationary. However, in its analysis, it did weigh factors. Now, there is both the case, that Smith case that the state cited, as well as Horn, which was a 2023 case from another panel in this that talked about those factors do overlap, and the court should distinguish when they're analyzing, and that did not happen here. Basically, it analyzed both enhancement and mitigating factors, and it analyzed the factors we would find in the probationary, but they do overlap, and that's the state's position. While this trial court should have distinguished and said, proudly, having been a trial prosecutor for 20 years, I would have addressed it first going into why is not diversion eligible, then going into why not probationary eligible. It didn't occur here.
Since that didn't happen, should we remand?
It's the state's position. I think that you have the opportunity to remand. However, the evidence that was presented at the hearing in the pre-sentence report, as well, both favorable for the defendant and as the state's position, the circumstances of the defense and the need for deterrence are not. And the state's position is this court has what it needs to review and review de novo. And in the end, it is clear that this court, maybe not with the reasoning of the trial court, but at the end, through a de novo review, should affirm the denial of diversion in this case. Does this court have any other questions? Thank you for your time.
Thank you very much, General. Mr. Camp,
Yes,
I think you still have your 3 minutes.
Thank you. Just in response to a few of the comments that the state has made in regards to this, I would just respectfully direct the court's attention to what is Volume 3, the sentencing transcript, page 30, where there is a letter read to the court from, in this case, Mr. Couvertier, and I'll not read the entire letter, but it says very clearly, I want to start off by expressing my sincerest apologies to the minor and her family. I want to apologize to my family. I've caused great pain to so many people and feel regret and shame for having caused this pain. I dedicated my life to helping and saving people while in service, and now I've let so many people down and have lost my ways. I cannot apologize enough to my wife, the minor child, in this case, and her family. I don't know any other way you can express remorse to the extent that he did in that letter, and I would respectfully disagree with the state in its analysis regarding that particular portion of Mr. Couvertier's remorsefulness and behavior as far as the sentencing was concerned. I think the letter expresses that very clearly, and it is in the transcript for the court's review. In addition, there has been numerous statements made by his mother, by his pastor, by people that he served in the military with, comments such as they would trust him around their own children, they would trust him with their life. He was dedicated to serving our country and things along
Mr.
those
Camp,
lines. Yes, ma'am. And
assuming we agree with you, I know you were short on time.
Yes, ma'am, I understand. But in any event, I think that Judge Hickson, you were correct in the way that you analyzed this as well. We have nothing to rely on here from the trial court level.
I guess
to
my
identify
question
that.
to you is, on de novo review, what is your strongest argument for why the circumstances of the offense don't outweigh the other factors: his military service, honorably discharged, serving the country, no criminal history, all of those things? Assuming you're correct and we review de novo, the state's saying it still doesn't matter because he's still not qualified for judicial diversion based on the circumstances of the offense and the deterrent effect necessary for this crime.
And, Your Honor, in response to that, I will tell the court this. We have reasons that we go through an analysis, including whether or not you're eligible in the first place. He was clearly eligible for diversion. Diversion is there to provide that opportunity to allow individuals not only to have to suffer for the instances that they committed, but also to provide them that opportunity to make up for it and not have this necessarily follow him for the remainder of his life. His life up to this point had been exemplary, and I think the court cannot deny or ignore that. I'm not in any way condoning the events that took place, but the question is, how much is enough as to the punishment that the gentleman should have to face for the consequences of what he did? He has now been separated from his family. He's lost his military pension as a result of this. When is enough on this? And I would submit to the court that under the circumstances, diversion is just a means by which he can start over, and there's no risk, amenability to correction, no risk that this will repeat itself in the future, and he's learned the lesson from what he created and what he caused.
Thank you,
That would
Mr.
be the
Kemp.
response. Thank you for your time. I appreciate it.
We'll take the matter under advisement. Thank you to the parties for your briefing and your excellent arguments. Call the next case.
State of Tennessee versus Marcus